Welcome back to Winning Isn't Easy. Sometimes cases read like a mystery story, sometimes they read like a horror story, and sometimes they read like a fairy tale. I'm going to explain how the carrier's use of the defenses we've talked about today were considered by one judge and how the judge saw through all those defenses. Now, I know we've thrown a lot of difficult and complex concepts and policy definitions at you today, but I hope that this story will put it all together for you. So let me tell you this fairy tale story of Mr. Chanhook. He was employed at Malloy Brothers Enterprises, which is a car dealership in Albuquerque, New Mexico. This story illustrates the importance of an interaction of terms in a disability policy and how facts matter. The terms are full-time active employee, last day worked, and disabled during and the elimination period. As I've said, disability carriers will weaponize these policy terms to deny a claim based on one or more or a combination of these coverage defenses. Now, the disability carrier will say you weren't a full-time active employee at the time you became disabled, therefore there's no coverage. They may say that you weren't disabled as of the last date you worked. They may say that you weren't disabled beyond the elimination period or during the elimination period. And they're going to use, as I've said, any one of a combination of these reasons. So let's work through the coverage denial games in this case. Chanhook was covered under a group disability insurance policy that covers all full-time active employees. Full-time employment means that an employee has to have worked at least 30 hours per week. Now, that's not uncommon. They'll set a threshold on the number of hours that you work. The policy went on to provide that disability benefits were payable when the insured became, one, disabled through the elimination period while insured under the policy. They were disabled through the elimination period, and they remained disabled beyond the elimination period. And of course, they submit proof of loss to us. So it was a continuous stream of disability at the time the person became disabled, through the elimination period, and beyond. And if you didn't meet the definition in any one of those periods, the carrier could deny your claim. Now, the policy terminated on the last day of the month or on the next following the month in which your employer terminates your employment, the date you cease to be a full-time active employee. Now, these terms are important because we have cases where the employee has been terminated and we're trying to figure out if there's still coverage. And that termination can result in the basically the termination of the policy. So again, these are all terms of art. You need to get your disability policy out and review it. But generally, policies will say that the term disability is the inability to perform the material and substantial duties of your occupation. So hopefully we've got some basic definitions here that we can work from and apply. Let's now talk about the facts of the claim. And in my view, facts of the claim are crucial when we're involved in these kinds of coverage defenses. They're date dependent. Chanhook claimed that he was injured on January 9, 2016 when he fell on his left knee. Despite his pain, he was a tough guy. He worked full-time between his fall and March 4, 2016. In fact, he was so tough, he didn't get any medical treatment until 1 week before he stopped working. Now, when he applied for his insurance benefits, he alleged that most of his job required him to walk and that his bosses told him to take time off because he was limping on the job. Ultimately, when he saw a doctor, he was diagnosed with lots of orthopedic problems, including low back problems and knee problems. So when he applied for his disability benefits, what happened? Let's talk about how the carrier used the terms that we just covered to deny his claim. His claim for disability benefits was denied on the basis that he was working while he was disabled and that his coverage had ended on the earliest of the following of the last day on or next following the month in which your employer terminated your employment, and that if he was disabled, any disability ended during the elimination period. Now that sort of contradicts itself, but the carrier is trying to cover all of its bases. So what was his counter argument to this? His counter argument was that the policy did not require him to prove disability with a doctor's note on the date of disability, that he was sent home by his employer on March 4th, that he was insured through the end of the month, and that he was an active employee on March 4 when he was sent home or March 15 when he was taken out of work by his doctor, and that he was disabled during this entire period of time, through and beyond the elimination period. Well, fortunately, the court agreed with Mr. Chandhook. The judge said first that there was no logical incompatibility between working full-time and being disabled from working full-time. In other words, just because you can work full-time doesn't mean that you're capable of performing the material and substantial duties of your occupation on a full-time basis. That's an important distinction, because the carrier got stuck on the fact that he was working on a full-time basis without paying attention to what the material and substantial duties of his occupation was. So it's not so much the question of the hours worked, but that can be relevant, but rather whether he was performing the material and substantial duties of his occupation while working full-time. So it was on this basis that the judge rejected the carrier's argument that since he had worked some 2 months after his fall, they could not possibly have been disabled on the date he last worked, or March 15. In other words, the carrier said, look, he was working. How on earth could he be disabled? Again, the carrier got hung up on this full-time employment without evaluating whether he was really performing the material and substantial duties of his occupation. Now, the judge took on the other defenses and said, look, Chandhook wasn't fired. He was only temporarily absent. As a result, he didn't lose his status as active at work. In fact, the judge said, look, if he had taken a vacation or sick leave, he wouldn't have lost his coverage. The plain language of this policy didn't require him to have worked full-time immediately prior to asserting coverage. Because the record reflected that he was on a short-term medical leave rather than permanently off work, the policy covered him until he was diagnosed and impaired as of March 15, 2016. Now, the court fortunately found that this decision to deny benefits was arbitrary and capricious and awarded benefits. I hope this story explains the games that carriers are playing with the terms actively at work, no coverage, no disability during or after the elimination period. If the carrier has denied your claim, I wouldn't be surprised, because they will routinely misuse and misapply these terms to deny coverage. They collect your gold and they rule that you're entitled to your benefits. But remember, there are lawyers like myself who can help you get the disability benefits you deserve regardless of where you live in the United States. We'll take on the disability carrier and address the misapplication and misuse of these terms. Well, that's it for this episode. Please, if you like this podcast, consider liking our page, leaving a review, or sharing it with your friends and family. This podcast comes out weekly, so tune in next week for another insightful episode of Winning Isn't Easy. You can learn how to challenge a wrongful denial of your claim by calling me at 727-894-3188 for a complimentary consultation. You can learn how to challenge a wrongful denial of your claim. You can call me today at 727-894-3188 for a complimentary consultation.